This was a pretty serious accident. My client's car was T-boned. It was a high-speed impact. She was taken by ambulance to hospital. She had a broken pelvis. She had a broken femur. And she was in her 50s. These were bad injuries that would take a long time to recover from, if she was ever going to recover enough to go back to her work, which required standing and walking for 8 hours a day. Now, fortunately, she had car insurance, which would pay her an income replacement benefit. And that was critical. She needed that money to pay her rent. She needed that money to pay her bills. Unfortunately, almost immediately after the accident, she got a letter from the insurance company telling her that her claim was denied because the policy had been canceled before the accident happened. Now, she was taken aback. She had never received a single piece of mail telling her policy was canceled, and she didn't understand why it would be canceled. She had set up prepayment with the insurance company. All they had to do is withdraw money from her account, and that'd be done. And she had money in the account, and part of the case was about whether or not there was money in the account when it was supposed to be withdrawn by the insurance company. And it was. All the evidence was that the money was there, and so she could have won the case on that basis. But there was another defense, and we had to deal with it. And the defense was that the insurance company had mailed her a notice terminating the policy. To do that successfully, there are some very strict technical requirements, including timing of when the notice was mailed. The insurance company, in order to succeed on that defense, would have to prove when exactly the notice was mailed, because that starts the clock ticking. Now, you can appreciate, insurance companies send thousands of pieces of mail a day, and it's going to be impossible for anybody in the insurance company's mailroom to say that particular piece of mail was mailed on a specific day, even though it may have been stamped that way, because sometimes a bag of mail doesn't go out till the next day. Maybe it doesn't go out for 2 or 3 days over a long weekend. Who knows? So that's a problem they had to surmount when it came to the arbitration. Well, they didn't, and they didn't even try. What they could have done, what they should have done, was bring a manager from the mailroom to describe all the very detailed and strictly enforced policies to ensure that the mail goes out on the date that it's stamped. They didn't. Why? I can only assume a lack of creativity. It would have required them to prove indirectly what they couldn't prove directly. But they didn't even try. For me, the lesson is in creativity. If a document doesn't exist, if there is no witness to a particular fact, you have to find a different way to prove it, because if you don't, it can be fatal to your case. At least try. And they didn't. And we won on that basis. And it saved the arbitrator from sorting through the very thorny question about whether or not there was enough money in the account on the specific days. There were some issues with the records. So they fumbled, we won.